Bob, thank you very much for your keynote speech and insights from the U.S. Treasury Department. Next up is the debate session, where certain policy aspects of U.S. international tax will be debated. As noted, this session is going to be somewhat audience interactive, as polling devices, handheld polling devices, are now being distributed to the audience. And you'll have an opportunity to respond to various polling questions during the course of the debate. The debate is going to be moderated by Willard Taylor, and the debate team includes Bob Stack, the United States Department of the Treasury, Professor David Rosenblum of NYU Law School, Professor Daniel Shaviro of NYU Law School, Paul Oosterhuis of Skadden Arps, Slate, Meagher, and Flom, and Michael Plowsian of KPMG. Willard Taylor was a partner with Sullivan and Cromwell for 35 years and remains of counsel to the firm. Willard is a former chairman of the tax section of the New York State Bar Association and is an adjunct professor at NYU Law School's graduate tax program. Bob Stack and David Rosenblum have already been introduced. Professor Daniel Shaviro is the Wayne Perry Professor of Taxation at NYU Law School and formerly served with the Joint Congressional Committee on Taxation. Professor Shaviro teaches tax policy topics at NYU Law School and is a prolific author on topics involving tax policy, budget policy, and entitlements issues. Most recently, Professor Shaviro authored a book entitled Fixing U.S. International Taxation, a very fitting topic for today's program. By the way, I checked Professor Shaviro's book, and it did not suggest an overhaul of the 385 debt equity characterization, so it wasn't him. Paul Oosterhuis is a senior international tax partner in the Washington, D.C. office of Skadden Arps. Paul is well known in the international tax community. Paul is a frequent author and lecturer, has taught international tax in the tax LLM program at Georgetown, and has testified before congressional tax writing committees on various tax legislative issues. Michael Plowsian is an international tax principal in KPMG's Washington National Tax Practice. Prior to joining KPMG, Michael was a senior advisor on base erosion and profit shifting at the OECD. In that role, Michael helped lead the OECD work on BEPS and worked with policymakers from the OECD and G20 countries to develop the action plan on BEPS. With that, Willard, over to you.
Okay, I'm just going to stand here. Very briefly, we've divided this into two sessions, if you will. We're going to talk for 25 or 30 minutes, Paul and David, on the 385 regulations that Bob Stack introduced, and that'll be sort of didactic as to what the regulations say, et cetera, although I'm sure it'll be contentious, knowing the speakers. And we will then move into our debate session where we have 6 propositions to debate. So with that, I think, Paul, you're going to begin by talking about what the 385 regulations do. You can do it from here if you prefer.
Okay, yeah, that's better.
And I'll just take your
I'll
seat
pick
if I
up
might.
from what Bob started to get into, and just giving you an overview of what they're trying to do without giving a technical explanation of the regs. As Bob indicated, there's 2 parts to them. One is the -2 regulation, which has documentation requirements, and I think that's seems to be pretty straightforward for capital structure type debt. I think there are some issues with ongoing funding from finance centers into affiliates, particularly for outbound multinationals in there that are funding CFCs on a day-to-day basis, where the documentation doesn't tend to be all that significant because the loans are short-term. And so I think there's some more work that needs to be done there. On the -3 reg is the main substantive reg, and as Bob says, the core concept in that reg is to define a related party group. It doesn't affect third-party borrowing. To define a related party group, and then at its core to say if you distribute a note to a related party shareholder, that instrument, the note, will be treated as equity instead of debt for all purposes of the code. It then goes on to say, and there are other transactions that are like distributions of a note, principally 304 type transactions where you use a note to acquire stock of an affiliate, and some asset transactions that are reorgs under Section 356 where you have boot in the form of a note that could be recharacterized like that. The 304 and the 356 are distribution-like provisions, and so Treasury decided that they should be within the scope of the rule. So all three of those apply where you use a note effectively to leverage up a related party group. So it's aimed at that kind of transaction, not at, for example, a real acquisition transaction. And it basically makes the fundamental distribution of a note into a recap. Interestingly enough, that means there's no withholding tax, presumably. So you are foregoing some revenue, at least in the short run there, because it would convert the distribution of a note and subject to withholding tax as a distribution of property into a recapitalization of the company. Now, if they had stopped there, I think they would have accomplished some goals with respect to inverted companies, because in at least some inversions, the distribution of a note or doing a transaction that's an effective distribution of a note is a part of the transaction, and wouldn't have that much impact on traditional inbound multinationals or on the outbound space. But I think the part that causes more difficulties and where there's a lot more work to be done, or at least a lot more thinking to be done, is in what they call the funding rule, because obviously it's there's a pretty fungible transaction to have where an affiliate borrows money from another affiliate and then distributes the proceeds out. That's the equivalent of the distribution of the note. And so the regulations say that too is subject to the rules. Not that the distribution itself is recharacterized, but that an affiliated loan that is in some sense connected to that distribution would be recharacterized from being debt to equity. And they come up with really a pretty broad rule in determining when you have a funding of that kind of distribution. And again, the distribution is either just a dividend distribution, a redemption distribution, or a 304 transaction, or an asset acquisition with cash or other property being exchanged. That's governed by 356 in many cases. So they have a broad rule that says if you have a related party loan within 3 years before or after the distribution in question, then that related party loan at the earlier of the time of that loan or the time of the distribution at the later of those two is converted to equity. And there they deviate from treating it as equity for all purposes, because they don't have the full impact of an exchange of debt for equity in circumstances where the note is issued before the distribution, so that you have a note for a period of time and it's converted to equity in a subsequent period of time. And that's an interesting area that they saw themselves as having authority to create an exception. And I think that's important going forward, because there's a lot of other areas where they ought to be thinking about creating exceptions to the plain treatment as equity, I would argue. 3 exceptions to this rule. One is distributions in an amount equal to your current earnings and profits. That is pretty tight, and of course you don't know what your earnings and profits are going to be until the end of the year, so you have to deal with it. It could be that having some more flexibility and maybe taking multiple years instead of a single year would be a useful improvement. Second is trade receivables are accepted. And then the final one is one that is a huge problem in my judgment, and that is the rule that says if this treatment of debt in form as equity is something that you did with a principal purpose for obtaining a benefit, then it's debt. And there are so many circumstances where an instrument being equity rather than debt is different, and in some cases advantageous, in some cases not advantageous, that it's going to be very hard to know whether, if you're aware of the advantages of it being equity, in a later period of time and end up taking advantage of them. Does that mean you had a principal purpose and therefore it was debt all the while? I think that's a rule that we need a lot of discussion of. So with that, let me turn it over to David to talk about the policy.
Grab his seat.
We'll rotate.
Yeah, okay. Yeah, so I think that there's a lot remains to be said, obviously, about these regulations. For starters, they're based on a statute that was enacted in 1969. And that was the subject of, I think, 3 different attempts to write regulations, one of which, if I recall, did go into final and then was pulled after going into final. This took a lot of effort. I was at the Treasury when it happened. It was the domestic analog to the foreign tax credit regulations. I mean, you had taxpayers screaming in both offices. So that statute has really not been, to my knowledge, reviewed carefully for quite a while. There haven't been any final regulations under it for quite a long time, and I think people got used to sort of viewing it, I wouldn't want to call it as deadwood, but as a piece of the code that was not receiving a great deal of attention. Let me say that I think that there are basically, Paul could correct me on this, I think there are basically 3 types of objection to these regulations. We have regulations all of a sudden that are, 47 years after the enactment of the statute that have come out and that have quite serious consequences. And I think there are 3 types of areas of objection. One, which I've already heard just talking to people, is the obvious one, whether that statute authorizes this kind of a regulation. And the thinking seems to be that this type of objection, that the context in which Section 385 was enacted was somewhat different from the way it's being used. It is now being used to target specific transactions, specific circumstances. One element, by the way, that Paul omitted to mention, I mean, I don't blame him because it's easy to forget, is that the regulation also gives the Internal Revenue Service the authority to treat an instrument as part debt and part equity. That could be quite significant, and some people have said that that could be the basis for settling an awful lot of disputes. I don't know that, but it doesn't seem to be that clear how the Revenue Service is to exercise that authority. In any event, the 3 areas that I see grounds for objection are: 1, authority. And the argument would be that in the 1969 era, what Congress was attempting to do was to ask the Treasury and the Revenue Service broadly to define the line between debt and equity. It was not in its genesis, I think, and viewed as an anti-abuse statute or a statute aimed at particular transactions. So the argument, the authority argument, it seems to me, would be that Treasury has revisited an area that Congress enacted a statute for one purpose, and the Treasury has viewed it through a somewhat different prism. And that's an interesting approach, and it may have some legs if the matter ever really does get to court. A second area, which Paul touched on, where I think there's going to be a fair amount of objection, and I see grounds for concern, is in the administrability of this statute. There are going to be it's going to affect an awful lot of people. It's not just an inversion statute, an inversion reg. It's interesting that I had personally a diametrically opposed view of this reg from what some people had, who said that this was really an anti-inversion step and that it applied more broadly than just to inversions in order to give some cover to the anti-inversion approach that was really at the core. Without prompting from anyone, when I read the reg the first time, took exactly the opposite position at least that was my initial reaction, that, and I think Bob said something that sort of led me to believe this might be more correct, that inversions was really just a springboard for doing something that applied more broadly. I personally have for a long time been troubled, including from some of the administration's tax proposals, objected to the emphasis on expatriated companies and the inversion transactions, when, to my way of thinking, the reason companies invert is that it's better to be foreign in the United States. It's as simple, really as simple as that. Our law is just way too generous to inbound as compared with outbound companies, and has been for a very long time. And so I read this as a step in maybe not the correct step. I'm not necessarily endorsing the reg, but I read this as a step toward rectifying the imbalance in favor of foreign companies doing business in the United States. And by the way, it's worth mentioning, because we all focus on the rules and the regulations. It's not just the rules and the regulations. The compliance effort by the Internal Revenue Service is wildly out of control in terms of much more attention being paid to outbound situations than to inbound. In my experience in nearly 50 years practicing, there's an awful lot of things that people can do coming inbound. With some exceptions, I think the foreign banks get a pretty good looking at by the Revenue Service. But by and large, you don't find, that I've seen, that many international examiners who are really willing to do much of a job on the inbound side. And I think an awful lot of things get swept under the rug. So it's not simply that the rules, which were written in 1966 and haven't been changed since to any appreciable degree, it's not simply that those are out of whack, but I think the whole slant of the Revenue Service, the whole attention of the Congress has always been toward outbound. And in fact, you know, I have conversations, including with people who are very knowledgeable, very good people working in international taxation, and indeed one of my friends, Gary Huffbauer, wrote a book, International Taxation. Not a word about inbound, all about outbound. That's all they're concerned about. Well, guess what? It ain't 1945 anymore in the United States, and sooner or later we have to wake up to that. And to my way of thinking, I think that this is, in that sense, a step in the right direction. The third question is whether this is the right policy. So my three grounds of criticism, or potential criticism, are authority, administrability, and whether this is the right policy. And I think there probably are other policies that would be conceivable, but I went back when the regulation came out, and I looked at Section 385, and if you read Section 385 through what I think is the prism that the Treasury is looking at it, I basically think that there is enough authority in Section 385 to justify these regulations. I understand that the context was different, but I had always assumed that courts would go on the language of the statute. And if you give the language of the statute a fair read, I think it's broad enough to justify where they have gone. Whether this is the right policy, there are plenty of questions yet to be asked and answered, but I think this is basically a fairly good effort. Now, before I quit, I will say confess one fact that probably transcends anything that anybody in this room would say, but I've written about this. It's not the first time I've said it. I basically don't think there's such a thing as related party debt, period. In a world in which you've got substance over form, I just don't see how related party debt can meet the red face test of whether it has substance. A corporation at the end of the day is just a piece of paper, and how two pieces of paper can do business with one another in the form of debt is beyond me. Now, whether they can do business in other forms, I'm open on that. But debt requires friction. Debt requires countervailing interests on both sides, and that's completely lacking in a related party debt circumstance. So I'm not as offended as I'm sure a number of people in this room are by this effort. Whether or not it's the right effort, I turn it back over to Paul.
Well, let me ask a question,
Yeah.
may I? And I'll give you back your seat,
Yeah.
David. But On inversions, of course, what was happening, as Bob pointed out and as you pointed out, was after the company inverted, there'd be a dividend of a note to take the equity out of the U.S. company, and that's certainly something targeted by these regulations. But they don't stop there. Let's suppose I had a non-inversion situation. How is that going to impact me as a foreign company?
Well, that's one of the interesting elements that are kind of elegant about these regs from the administration's policy perspective is that, I mean, a U.S. company that does an inversion, by definition, has no related party debt into the United States at the time of the inversion, whereas your typical legacy foreign multinational, if they're well advised, has a lot of debt in the United States. I mean, it's foolish not to at a 35% tax rate in the U.S. and lower rates outside the United States. So if what they are going after is the company that becomes leveraged, not the company that already is leveraged, and an inverted company, if leverage is part of the rationale for the inversion, then is going to become leveraged. If it's not through a distribution, it's through one of the things like the purchase of parent stock, to the extent you can do that in the transaction under the 367B-10 regs or something like that, that allows you to leverage up. So it has a differential impact on inverted companies compared to legacy multinationals, at least those legacy multinationals who are well advised and have, if you will, a base level of U.S. related party debt. Now, for the legacy companies, as their EBITDA grows over time, they won't be able to keep their leverage up unless they have acquisitions that they do that give them the opportunity to increase their leverage, or they have third-party debt that's parent guaranteed that they decide to move into the United States because that's outside of the scope of these rules. So, I mean, I know that a lot of the foreign multinationals are very concerned about this, and I can certainly appreciate that, but the impact on them, if they had been doing what was economically in their interest, and that is having a lot of leverage in the United States all along, it has not a huge impact on them. And I would see this in any case. Lee Shepard and I were talking about this over lunch, and she says, well, tax reform's not going to happen for 30 years, so don't call it a temporary patch. But I'm more optimistic about tax reform, and to my mind, this is a temporary patch until tax reform, because if we have tax reform, as Bob was talking about, we will enact something along the lines of Action 4 of BEPS or the administration proposal, which will be a much tighter 163J type limitation, including a similar application to third-party interests, so it affects U.S. resident companies as well as foreign. And under that regime, you need to be able to do leverage distributions in order to get interest deductions in the countries where you can use them. Because if everybody adopted Action 4, and Action 4, the report acknowledges this, leverage distributions, they don't exactly talk about it as leverage distributions, but intercompany debt is the tool for taxpayers to self-help themselves into getting interest deductions up to their EBITDA level in various countries. And there's nothing, if you're going to allow an interest deduction at all, there's nothing wrong with getting the right amount of interest deductions in the various countries. In fact, the system is intended to let you do that. So there's something fundamentally inconsistent about the 385 approach of saying, it's the leveraging up that's the bad, not necessarily the absolute level of leverage. And that's inconsistent to my mind with Action 4 and the legislative proposals. And so I would hope that if we did get reform enacted where one of those proposals was a part of it, we would get rid of these regs.
Paul, isn't there a third category of cases? You mentioned the legacy foreign-owned U.S. companies and the inverted companies. What about the acquisitions, the non-inversion acquisitions by foreign companies? Aren't they going to fall afoul of these as well?
Well, if it's a cash acquisition, that's a purchase, so you can leverage it up. It would only be if it's intended to be tax-free to the shareholders of the U.S. company. I think that you would have a problem. Most of those acquisitions are not, and the shareholders don't
But if
care
you were,
that much about it being
if you were, take the Nestle case, we talked about that. I mean, if you were making, you had a well-capitalized U.S. subsidiary, you were making a U.S. acquisition. Okay, if you made the acquisition and then sold the acquired company to your existing subsidiary for a note, you're covered. right?
Yeah, that's
Okay,
right, but you don't have to do it that way.
you would
can
say,
have the
you would
US
say
subsidiary
that's
buy it.
dumb, that's dumb, you did the wrong thing.
You did the, yeah,
You
you
should
didn't
have
hire the right law
had
firm,
the,
right?
that's right,
Yeah.
that was silly.
Yeah.
You should have had the US company make the acquisition,
Yeah.
financed by parent company debt, and that's okay,
That's right.
right?
Yeah,
So-
that's right, that's okay. I think where these regulations really have problems is in the outbound side, because apparently, Bob, you felt you needed to apply it across the board and not just inbound. And in the outbound world, the differences between debt and equity are much more ambiguous. There's not a clear preference for debt over equity when you're dealing with two CFCs. But the consequences of the characterization is enormous, right? I mean, dividends and interest granted are taxed the same in Subpart F, but dividends bring credits if you have 10% of the voting stock. They don't bring credits. In fact, you lose credits if you don't have 10% of the voting stock. And interest leaves the credits in the 902 credits in the pot of the interest payor. Further, and maybe even more importantly, when a note matures, you pay it back, and that's just a 1001 event to the holder. All the E&P stays where it is. But if it's stock and you're redeeming it, then under 302, because you're all within an affiliated group, your E&P moves from the company issuing the deemed stock to the company holding the deemed stock. And that can be really good, that can be really bad. Obviously, losing the credits in that deemed distribution is not good, but there may be ways that maybe that company already owns 10%.
We're coming to
of
the
your
end
voting
of our
stock.
time, but Bob, do you want to say anything on this subject, or?
Couple of points, I guess. To David's question of inbound versus inversions and kind of the impetus for the rule, I think it's fair to say you can see the panoply of circumstances in which the note could cause the problem. It could be the acquisition, it could be the inversion, but it could also be in certain domestic settings as well, outside the consolidated group. And so in that sense, I think we were reading them broadly. In terms of authority, I'll just say I think I appreciate David's analysis, but also if you go back and look at some of the legislative history that we cite in the preamble, I think it really makes it, I think, from our perspective, a relatively easy question, that the Congress definitely wanted us to have the tools and not be kind of tied to any specific way of dealing with this conundrum. So, and in terms of David's points on outbound, I mean, I think these are, we're hearing now the regs are out. We're taking these comments back. We're noodling them. This is a good faith operation as we move from now to finalizing. So these are harder questions on the outbound side, and we'll give them full consideration.
Okay, so let's move on, unless anybody else wants to chime into the debate. And you all should be armed with this audience response system so that you can respond to the debate, and we can figure out who's right and who's wrong. The first debate proposition, which leads right out of our 385 discussion, does relate to the 385 regulations and whether it's a good idea or a bad idea. And maybe, Michael, we haven't heard from you on this. What do you think?
Sure. So I would say that I certainly understand the policy concerns, Bob, as you've said. I think a lot of people have acknowledged that these types of transactions are maybe too easy. I will assume away the authority issue, but I think, and maybe this is arguing a little bit against self-interest, my objection to the regulations, it really has to do with the approach says that it matters a whole lot when and how the debt came into being, right? So if it is put in at the beginning, right, as Paul and David have said, it's fine, right? Whereas if it gets distributed out or in one of the funding transactions, it's not okay. And that really increases the value of tax advisors, right? And so I think as a taxpayer, I'm concerned about that. I'm not sure that that's necessarily the approach that would be the best way to address these kinds of concerns. I tend to agree with Paul that a better way to address these kinds of concerns is on a more systematic basis, the type of tightened 163J approach or the Action 4 approach that would look more to the overall economic characteristics of the group. Recognize that's not on the table. 385 is the tool that Treasury has, but I do think the approach is certainly problematic.
Dan, what do you think of these?
Okay, great. I'm going to say good idea. Got to give Bob some support here. But I just want to make 5 quick points. The first is to the audience to be intelligent consumers of this debate. I was very pleased to hear how fair-minded the comment in the prior 30 minutes was. But this is the type of topic in which the public debate is going to be very slanted in favor of criticizing the regulations, recognizing that there are 2 sides to it. Basically, there are a lot of people out there who have client interests against it, and in addition, there are a lot of practitioners who kind of figure, well, they like the way the world was working before, darn, do we have to learn these new things now and figure if we can get around them or not? So there's bound to be a kind of bias in the discussion. Now you have people like Steve Shea and Steve Rosenthal out there who are taking the pro-government side of this, but people like me, to be honest, and maybe it's to our detriment and a criticism of us, we're potentially going to be on the government side in this. We're not pro-government all the way. By we, I mean myself and people like me. But we tend not to get this much into the weeds. So maybe it's our own fault and it's a criticism of us. We kind of under-participate in this type of debate, and that contributes to its potentially being slanted overall. So you just want to be a smart consumer of the debate and realize that there are these built-in biases. Second point, I'll just say, and I agree with David, 385 really gives the Treasury very broad reg authority. It's really meant to be a broad grant of discretion for them to do what they want. I don't mean to overstate that, but it's a very broad grant of discretion. And by the way, this is a good thing, at least if you want the regs to be upheld, because the Treasury recently suffered a very grievous defeat that they're appealing in a transfer pricing case called Altera that has broader implications, suggesting that taxpayers that don't like Treasury regulations can kind of flood the zone, so to speak, in the notice and comment process to kind of throw up every objection possible. And then if the Treasury doesn't write reg preambles as a litigating brief, they could potentially get reversed. I'm less worried about that here just because 385 is pretty clear on how broad the authority is, but it's another thing to be concerned about in the future. Third point, conceptually speaking, I kind of see this as a move. Again, I think I may be like-minded with David a bit on this, even if he comes out differently on the bottom line, that it's in some ways kind of like a move from separate entity accounting. Obviously, that's not doctrinally what it is, but it's kind of a step in that direction of recognizing that wholly commonly owned groups, it's kind of silly to, for many purposes, to pretend that they're not wholly commonly owned. And I see this as kind of a small incremental move away from that, and I do think that's the direction in which international tax law in the U.S. and elsewhere really has to go. The fourth comment I'll make, and I won't say anything more about this because it's going to be in a later debate topic if we have time, is I do think it's very important that this addresses inbound, not just inverters. And the question of inbound, I think this is again something I think we agree about, is really important and needs to be on the table more than it's been. But we'll say more about that later. The fifth thing I'll say is I think one thing that people really disliked about this and about the previous stage of Treasury regulations was that what the Treasury has done is in some ways a violation of old-style comedy, with an IT, not comedy, that it used to be when an issue of this type comes up, it's kind of quasi-legislative. You wait for the Congress to act, you work with the Congress, you don't jump the gun like this and issue regulations. This is not a rule of law. This is a kind of, again, a rule of comedy, a rule of cooperation and of the two branches, not counting the courts, working together and so forth. I think the way the legislative process is going today, inevitably, this old comedy norm is going to fall by the wayside. And if not by this administration, then by the next administration, whichever party it might be, Democratic, Republican, or Trump. I guess there had to be a Trump joke, didn't
Well, there
there?
had to be some comedy in this
Right.
thing. So.
That would be the other type of comedy, yes. But it might have elements of tragedy also, I guess. Anyway, I really think we've moved to an era where these old norms are kind of dying, and there's nothing that can be done about it unless the political system changes in more fundamental ways. So people who are unhappy about the Treasury jumping in like this, both this time and before, they're quite right that that's not the way things used to work, but the world has changed, and that's just where we are now, I think.
Yeah, so I'm not going to ask you guys to comment on this because you've made your statements in the interest of time. Let's move to the questions, which are, the proposed regulations are a good idea. Companies should not be able to manufacture interest deductions by the mere distribution of a debt instrument. The proposed, alternatively, B, the proposed regulations are a bad idea, as it appears inappropriate to rely on a broadly worded statute enacted 47 years ago that has never been interpreted in the final regulations to address a particularized issue such as this. So everybody's got their thing to vote with? Yes? You're voting? No? So, do you have these things? You should.
A few people do.
Yes?
I gave them to the right people.
Okay. So here it is, 54%. This is like Bernie and Hillary. 54% think the regulations are a good
primary day.
idea,
Oh, wow.
and 46% say it's a bad idea. Very close.
That's not very close. That's a landslide.
That's the last slide. Okay, you're right. It is.
Hey, Willard, before we go on to the next topic, I just have Bob talk to us a little bit about.
But we're not revoting.
No, we're not revoting, but just about some of the issues that we started to raise on the outbound side, where it is ambiguous as to whether debt or equity is good or bad, and it moves E&P around, and you
Okay,
lose foreign
very
tax
quickly,
credits.
Bob, because we
And-
have to move on.
So we
and,
want
and you have the anti-abuse rule in there too.
Yeah,
that
we
you
want,
can't use it for
we
your
want to
benefit.
look at that. I mean, Paul and I talked about this. I mean, we're going to think about all those things, whether the rule that says the IRS can come back later and treat it as debt anyway if you tried to affirmatively use the rules. And so we don't want that to be a pit of hopeless uncertainty and a complete hindsight for the IRS. So we need to work through some of those examples, and also shifting the E&P around. You could do that with stock from company to company. Is this really different? And so those are cool things that we're going to dig into and see.
Okay, so on to number 2 here, state aid, just by way of background. State aid are selective deals for some taxpayers, not available to others, and if there is state aid, it violates the EU treaty. The benefits of the state aid to the taxpayer, if it's tax state aid, have to go back to the state with compound interest, 10-year clawback. In June of 2013, the EC began to investigate rulings that had been issued by member states, Luxembourg, the UK, Ireland, the Netherlands, then broadly all countries, and they initiated state aid proceedings with respect to Amazon, Fiat, McDonald's, Apple, Starbucks, and a number of unnamed Belgian companies. And so what do we think about state aid? Michael?
Okay, so here's something again where I think that it's understandable why the EC acted the way it is. They were under tremendous pressure to do something about rulings. As Bob mentioned, the LuxLeaks event really put pressure politically on the commission, and state aid is the tool that they had. So that's sort of where they were. That all said, this is a tremendously bad idea. It's the wrong remedy. It's retroactive when what the commission is really trying to do is change future behavior of states. It's the wrong result. I guarantee that France, that Germany don't think that the right result is more profits in Luxembourg. It's also the European Commission and trade lawyers imposing a different standard for transfer pricing than what has been agreed internationally at the OECD, right? The Commission decisions, if you read them, say that the OECD guidelines inform their analysis, but they're not really controlling. There's a different standard that the Commission applies, the prudent market operator, whereas the OECD guidelines in the Commission's view give you a range of possible answers, possible numbers. The prudent market operator might give you a single number that is the right number in the Commission's view. which leads to a lot of uncertainty and obviously different standards being applied to the tax analysis in these cases.
Sorry,
Yep.
We should, I'm sorry, I didn't mean to interrupt you. Or-
Oh, okay.
Yes.
So I think this is really a very unfortunate situation where politics has sort of gotten the better of the analysis here, and is something that should be strongly resisted by the U.S.
Bob, you've spoken a lot about this.
Yeah, I'll just make 2 quick points in the interest of time. You know, first of all, I had a conversation with a German colleague over the weekend at the IMF spring meetings, and one of the things that's kind of fascinating to me is in much of Europe, they are complete, and I'm talking good faith people who just know their system. They are completely baffled at the U.S. response to this because they have an extraordinary faith in the integrity and ubiquitousness of state aid law in Europe. And so I had to have one of those conversations about, we really don't understand why you're upset. And I'm like, really? $10 billion, 4 out of 5 companies? But let me just make a technical point. You know, our core argument with the Commission is fairness. We're trying to go around the world, set standards, get people to do things by the rule of law. When India does retroactive law changes, you know, we all get very anxious and upset. And that was our interest. There was a suggestion a couple of weeks ago, I think it was Ed Kleinbart in Congress, that we were out, you know, defending multinationals who can stand for themselves. Well, the U.S. interest in these cases is a potential U.S. foreign tax credit. And number 2, it was important for us to speak up when there were 4 companies under the microscope, but before there were 44 countries. And sometimes, given the political environment in Europe, you're never sure. We've asked the Commission, as a matter of fairness, in what way were taxpayers on notice that state aid could be applied this way? And what we've said very specifically is, were taxpayers on notice that particular rulings about transfer pricing could be re-examined by the state and measured not against the local country's view of an arm's length price or even the OECD standard, but against a European Union notion of a market price. And we've asked, and I have to say, nothing we've received back satisfies me that taxpayers were on notice for this particular type of an attack that could raise this much money, and that is a core concern of ours, as our Secretary has expressed.
Dan?
Well, the debate proposition is funny in a way because it's almost taking the question not of what's good for the U.S., which is kind of what we are, you know, voters and so forth on, but what's good for the EU. I think it's desirable just to kind of understand the whole situation here, to understand how much sense this might make from an EU standpoint. Again, whether it's good for us or not, whether we like it or not, it just helps us to understand them better. So I think it's quite understandable that if they are trying to prevent their internal countries from engaging in certain types of tax competition with each other, that they'd want to take the state aid perspective, even if it hadn't been anticipated, and that it would be, quote, retroactive, because that's the way judicial decisions work, after all. And if they kind of said, well, gee, you shouldn't have done this, but next time we're really going to be mad. We'll let you do it this time. So I find the entire thing very understandable and logical from an EU standpoint. That's just good for us to know. We may dislike it. Obviously, the worst feature from a U.S. standpoint is the idea that there's no benefit to the U.S. from U.S., or at least no direct benefit from the U.S. firms paying more taxes to EU countries, even without the foreign tax credits, even if they never bring the money home, because we don't get the revenue, and that's something I've written about for a long time. That said, actually, there is a possible indirect benefit to the U.S. if U.S. companies become kind of convinced that they can't, shifting profits to Europe isn't going to end up with them not being taxed anywhere. They might do it a little less. So there's a little bit of a benefit potentially to that from the U.S. standpoint. So fundamentally, there is reason for us not to be thrilled about this, but they were doing it for themselves. And I do think it's important to understand the kind of logic they had in mind and why they may reasonably felt that it was in their interest to do this.
Dan? David Toohey.
Well, I probably am the most ignorant on this subject of anyone on the stage. I find it very hard to understand, contrary to Dan, what the EU is about here. as I understand it, the charge is one of discriminatory rulings that they're giving to certain companies that they wouldn't give to other companies. That's my understanding. Maybe it's wrong. If that's correct, I mean, would it be a perfect defense if Luxembourg came in and said, we'd give the same ruling to anybody who walked in our doors? And that's probably true. I mean, is there really discrimination going on here?
Well,
Aren't they aiming at
there's
the wrong
a
target?
difference of interpretation as to what selective means.
Well, but if they
And
give the same beneficial ruling, whatever it is, to anybody who asks for
It's
it,
the EC's position, I believe, that if that's inconsistent with the law, then it's selective, even though everybody could have gotten it.
And
I
if you're,
think that's-
if you're
but the
operating only in the
problem from
domestic
a
market.
U.S. perspective in these countries, particularly, let's name names, particularly in Luxembourg, is that they've got a thoroughly corrupted tax system. And so, I mean, so what are we talking about here? That's the problem, not that they're discriminating.
Paul, do you have anything?
I had some of the same reaction
David said
as David, because from practice, you know that a broad group of people can get these results, not always in the same way, but they can get these results. So it does seem not to be discrimination. And Lee obviously is jumping up and down here.
Lee, you get to vote, no questions. Okay.
Yeah.
All right,
Right.
so
No,
we
it
have to
doesn't.
move
No, it
on.
doesn't.
So
I
we have
disagree
some
with you.
vote,
I don't buy it.
some polling questions here. Yes, it's appropriate to retroactively revoke rulings that represent state aid. B, no, it is inappropriate and inconsistent with the premise of U.S. tax treaties with EU member states to retroactively revoke tax rulings. C, there are better ways to address the issue. Perhaps revoke the rulings prospectively, not retroactively. Are we all voting? Okay.
Wow.
Only 14%, this is really quite different. Yes, it is appropriate, 14%. No, it is inappropriate, 20%. C, there are 65%. There are better ways to address the issue. So that's the outcome of this.
Pretty rational.
Okay, so third debate proposition. Given the EC's almost exclusive focus on U.S. companies, even Fiat in this paradigm, in this list is a U.S. company, should the U.S. invoke Section 891? Now, no reason you should, but unless you've been reading the tax press recently, but Section 891, which came in 1934 to deal with some French tax rulings, apparently, authorizes the doubling of taxes on citizens and corporations of another country if that country discriminates against U.S. taxpayers. So, Bob, do you have a comment on this?
No.
No comment or inappropriate?
You know, we wrote, we've said we're examining all our options, so.
Right. Paul, what do you think?
Well, to my mind, the threshold issue is, you know, it's not the countries. Retaliating against Luxembourg companies or Irish companies doesn't accomplish a lot. You'd have to, and I think Ty Grinberg got into this in his paper, you'd have to see kind of the EU as being a country because it's the EC that's causing the problems. And I think if for no other reason, then it falls apart there.
Dan, do you have a view?
Well, the thing in favor of at least threatening 891, though I would be hesitant to do it, is it's always nice to bluff if it works. If you say, we're going to do something you don't like, unless you do something nice for us, if we assume up front that it's going to work, they're not going to call your bluff and they'll give you something you like, then sort of by definition it's a good idea. So you could imagine this, at least bluffing an 891, being a good idea. That said, it's often not a good idea to bluff, especially if you're not really willing to pull the trigger, so to speak. And I question whether we really should be willing to pull the trigger here, and that I think feeds back into maybe not being a great bluff idea. I think that insofar as there's a concern that they're singling out U.S. companies in particular, by the way, just as an aside, even though it's mid-sentence, I guess, I was at a conference last week where a non-U.S. tax lawyer said, he said about BEPS actually, but I guess it would apply to this too. You've been invited to the meal, you being the U.S., but you're not one of the guests. You're the meal. So there's a little bit of that flavor to this. But I think if we're not happy about this because of the focus on U.S. companies, and again, there is some possible benefit to the U.S., even though we don't get anything from our companies paying more foreign tax, if U.S. companies do less kind of shifting tax base to Europe because they figure they won't be able to get the benefits from it after all. But anyway, leaving all that aside, I think we have an inbound issue, and if we, if they're sort of focusing on inbound to them from the U.S., from U.S. companies, the kind of logical way to respond is to see whether it be through regs, through legislation, or just through administrative practice, what is there going on by inbound investment from EU companies that leading to profit stripping that either we could change the law, well, they just issued these regs, or there's something else we could do. I think that's the right way to quote, retaliate. Again, it's something we might have wanted to do anyway, is look more at inbound from EU companies. That's sort of the logical way to address concerns that they're targeting ours too much.
Michael?
Yeah, so I don't think that there are a lot of people who probably think that actually collecting tax under 891 is a great idea. Tax wars are probably not the best thing for our economy at the moment. But I do think that it is, as Dan says, if it's possible to bluff and provide some leverage, there aren't a whole lot of options, I don't think, for the U.S. in terms of imposing leverage against the EU in the state aid investigations. There was some talk about, could the U.S. deny foreign tax credits? I'm not sure that's really leverage against the European Commission. Making noises politically is also probably not very effective against the Commission. In fact, it may help them politically to be standing up against the U.S. And so I think it is something that provides a little bit of leverage. Perhaps another way of exercising a little bit of leverage is rethinking the treaty policy of the U.S. with respect to EU member states and whether the European Commission, because of its role in indirect taxation now, needs to be part of those discussions. I think you might see some of the bigger EU states respond pretty quickly to that suggestion.
David?
I think this is a really loopy idea. I mean, the most interesting aspect of it, to me, was it forced me to try to figure out the relationship between Section 891, which is always cited, and Section 896, which says virtually the same thing, but which is not cited. And that was kind of fun. But apart from that, even if Treasury was 100% in favor of doing this, trust me, the State Department would not let this idea get out of the starting blocks. This is a purely academic question. However, I will say one thing. I agree with Dan that if it takes this to have us start thinking about doing something on the inbound side, I'm for that.
Okay.
Before we
So-
move on, could I just add one
Sure.
point? Going back to the opening remarks I made in my speech, it's a mistake to view any of these issues so narrowly as 891, not 891, will they come off state aid or not? I probably deal with Europe 4 or 5 times a week on a variety of issues. And so as do other agencies. So you're always trying to find that right place of kind of cooperation with a large ally, and there's many, many places where it's really important that we're cooperating with each other and working productively. And so there are lots of places in which actions like this can hurt the relationship, perhaps in ways that are not so obvious as an 891 bullet. So I just want to be sure we understand that.
Okay, so what do you guys think? We're going to vote on this? Yes.
Oh, they're going to vote.
Are we voting?
We are.
A would be a who. Let me see, though. Yeah.
Well, 15% think it's a tax war and we should open fire. 26% say no. 891 was not enacted for this purpose and should not be invoked. And 58%, I think persuaded by Dan and others, say while we shouldn't invoke 891, it should consider more measured responses, such as focusing on EU multinationals that invest in the U.S. which leads into our next debate question.
I have no clue how that slide got in there, Willard.
Thank you for that, Larry. That's great. The fourth debate proposition is the U.S. discussion of international tax reform disproportionately focused on outward investment by U.S. corporations. What about foreign investment in the U.S.? Can the two be separated? And then, is this in part what the proposed 385 regulations are about? Should the U.S. consider a U.S. version of the UK diverted profits tax? Should the U.S. challenge the supply chain structures and or significantly broaden and tighten the earnings stripping rules? So,
You want me
Paul.
to start?
Yeah.
I would say in the context of broader tax reform where we're reducing corporate rates, assuming we ever get to that point, we definitely should be considering some of these things. Part of the goal of international tax reform in that context should be to level the playing field between U.S. multinationals and foreign multinationals so that there aren't such incentives to divert as there are today. You can't get rid of them completely necessarily, but you can certainly adjust the dial to make it more of a close call as to whether foreign multinationals are better off than U.S. multinationals. Some of that means going more towards a territorial system, but some of it also means making sure we collect tax on U.S. source income and minimize the amount that's stripped out both through interest and through transfer pricing. The diverted profits tax, to my mind, is a pretty not only complicated but not particularly effective tool. And so I think it would be great for all the smart people in this audience to think of other things that could be done. Maybe limited risk distribution, for example, something OECD decided not to tackle. That might help the United States collect revenues on basically sales in the United States.
Michael?
Sure. I think I agree with Paul on this 100%. I think that over the past couple of years, both on the base erosion piece of tax reform, we've seen more emphasis, more attention on sort of the minimum tax approach, trying to make sure that U.S. multinationals are not eroding the base, and less so on base erosion by inbound companies. I think, again, that if tax reform is moving toward a territorial regime, if there is some hope of a lower rate, then again, we do have to raise revenue somehow. Again, a greater focus on inbound taxation is going to be necessary. I think I probably have a different view of the diverted profits tax than probably most people in the room. I think on the PE piece of it, a lot of that has to do with going after some of the abuses that the U.S. addresses through case law and other mechanisms. And so there really is a greater emphasis on transfer pricing, and that's what the UK is trying to do through the diverted profits tax. I think that the US could take a closer look at some of the transfer pricing principles that we've been using in terms of moving more toward protecting the base on the inbound side.
Bob, you have any?
Well, I largely agree with the previous speakers. I would just add two things. One, our budget proposal has something on inbound interest and also on outbound interest, so you're not getting deductions for the income that could be deferred under certain circumstances, although there are fewer circumstances in our minimum tax proposal. The only other thing I'd say on, I thought the UK diverted profits tax is inconsistent with PE rules in our treaties, and so I don't advocate us going down that road. And on supply chain, et cetera, look, I just think it's important that we've written rules based on functions, assets, and risks and transfer pricing. We should all just apply them and live with them, and they make broad sense. So I don't think we should be stepping out of principles that we agree to, in the global space.
Yeah.
Well, there's from the standpoint of the audience, there seems to be a distressingly high level of agreement on the panel today. I'm really sorry about that, but I'm not going to destroy that consensus right now. I would, in general, want to separate two questions. One is how tough or not tough our attempt to deter profit shifting by multinationals should be. That's the first question. By the way, Marty Sullivan had an article in Tax Notes this week seeing earnings stripping as an incentive to get foreign companies to invest in the U.S., and whether or not one agrees with that bottom line, that's got to be part of the conversation. So that's the first thing, is how tough should we be in profit shifting? I want to leave that to one side. The second question is, to what extent should we focus on outbound versus inbound in doing that? And I think one problem with the U.S. rules today, which has led to which along with the whole deferral earnings abroad issue has led to the inversions, is that we have placed too much relative emphasis on the Subpart F rules compared to other stuff for trying to deter profit shifting. Obviously, earnings stripping, if you're naive enough and you haven't hired Paul or David, and you think, oh, I'm just going to be a U.S. company, I'm going to do a debt transaction with my CFC, and you're not kind of aware that the CFC's interest income will be so, idiotic though that example is, if that rule weren't there, that's what people would do. So the virtue of using the Subpart F rules to address profit shifting is you can decide which types of foreign source income you kind of want to get. And most countries, including so-called territorial countries that have CFC rules, they tend to address either highly mobile income that's likely to end up in a tax haven, or they actually look directly at whether it's in a tax haven like the Japanese rules do. So the great virtue of using CFC rules, which only apply to your resident companies, is that you can kind of target the types of foreign source income you want to get at because you think they're related to profit stripping. The vice of these rules is that you avoid them by not having a resident company. So I think we've gotten out of whack. Again, whether our profit shifting, even if you think that our profit shifting is too tough already, it's out of whack between the outbound, which you can obviously for the outbound you can use CFC rules, and for the companies that are coming inbound, it's kind of harder to do that. So I think we've been out of whack, and we need to rebalance. It does seem to be going that direction. I guess everyone on the panel kind of agrees with that.
Well, no, we still have to hear from.
So far.
So far.
Well, I basically don't disagree with anything that's been said to the extent I understand it. But I do think
another
that
issue.
there are two things. My view on what we should do inbound is much broader than just worry about earnings stripping and profit shifting. I think we really need to take a hard look at what we're doing. For one thing, if I ran the zoo, I mean, I would try to conform our statutory rules to our treaties. They've always been out of whack, and we're not going to change the treaty, because if we do, we're not going to get any treaties. So we now have two sets of rules that operate in parallel. We've lost two major cases in the tax court, and there's a whole lot of vulnerability out there on that gap, which has never been satisfactorily bridged. I would spend some time trying to get the law right. The other thing I would do, and I know some of my colleagues are shocked by this, is I would delete the non-discrimination clause from non-discrimination article from U.S. treaties. I don't think it belongs in a double tax treaty. We do not intend to abide by it. We don't abide by it. We regularly discriminate, and we either say we're not discriminating, or if you don't like it, you can choose to be a U.S. company, or gee, we've got a good justification for doing it. We have a million excuses for discriminating. Once upon a time, I negotiated with the Australians. It had been 10 years, that treaty in the making. The Australians would not sign a non-discrimination clause. I was naive. I said, gee, John arrived. John, why won't you sign it? He said, it's easy. I'm not going to sign it because we want to discriminate. He paused for a second. He said, you know what? You do too. And he was right. So I think that ought to go too.
All right, so what does the audience think? We'll vote on this. A, yes, since our rules for outbound investment are designed to protect the domestic tax base. For proper balance, we should also tighten the inbound rules. No, these are separate subjects, and changes to the outward investment rules can go ahead without changing the treatment of inward investment.
It's like 80% A.
69% agree with the panel. It's pretty, considering we were all on the same page, that's pretty weak, guys. Yes, since our rules for outbound investment are designed, et cetera, we have to address inward. And 31% say no, separate subjects. You didn't persuade me. You go ahead and do what you want to outward and take up inward later on. Okay, the fifth, and possibly, unless we get an extension, the final debate question is without any way to force members to sign on, is BEPS going anywhere, or will it become irrelevant? Will it make a meaningful contribution to the international tax rules or just cause disruptions? Bob, you've spoken a little bit about this before in our session. What do you think?
I think I've heard people say over and over again, it's much more impactful than people anticipated at first. You can look at country by country reporting. You can look at the changes we're going to see in the Swiss and the Luxembourg tax systems. You can look at exchange of rulings. You can look at, I think it's going to be far more difficult to keep income in zero tax places, both because of country by country and because of the change to transfer pricing. You can look at the follow-on effects, public country by country in Europe that's been proposed. So I think this thing has legs. I think the challenge for all of us is to try to move it, and shape it in yet even a better direction for international coherence and certainty for taxpayers.
David?
Well, I certainly think it's going somewhere and it will not become irrelevant. I object to the word "or" in the second question. I think it's both going to make a meaningful contribution to international tax rules and cause disruption. In the short term, it's going to cause a lot of disruption, I think, because I think you're going to have a chaotic period of time while countries adopt whatever they adopt and have already adopted. But over the long run, I think this is probably the most significant event in international taxation in my professional lifetime. I think it's clearly going to have a huge long-term impact, but it's not going to happen tomorrow.
Dan?
Well, I wish I had $1 for every panelist on every panel who's discussed BEPS anywhere in the world in the last 3 years, because I could probably take a helicopter to my mansion in Long Island if I did. This is kind of asking for a prediction, and I'm sorry just to repeat a line I've used before, but Yogi Berra was wrong for once when he said it's hard to make predictions, especially about the future. It's actually very easy to make predictions. The only problem is whether they'll be right or not, and when you know that. I'm a little bit more on the ground of a skeptic about how much is really going to come out of this. Clearly, there are things happening, including on reporting and things like that. Also, to some extent, if there's a change in the international tax environment, then BEPS becomes kind of a harbinger or an instrument of something that was happening anyway. I'm a little skeptical of how much is going to come out of it in the long run, both because of the fact that they really have no means to force cooperation, and countries are going to have to decide what they really want to do, which was true before, and also because it is using the traditional methodology of separate entity transfer pricing and so forth. So obviously, like the cheap cynicism saying, oh, nothing's going to happen would probably be naive rather than sophisticated. Nonetheless, I tend to be on the low end of how much is really going to come out of this.
Paul?
Yeah, I think the contribution side is hybrids and interest allocation. I think both of those are meaningfully positive steps, and as we're seeing in the UK now, as Bob mentioned, they're adopting rules along the lines of Action 4. As we talked about earlier, we'll probably adopt them. That is pretty constructive. I think the transfer pricing area is where the disruption and confusion is, because this whole concept of managers of risk getting the reward is just ass backwards in transfer pricing from my perspective, and it gets you into the subjective area of, who's doing the management and the kind of, the people in our country are doing it versus the people in your country doing it, particularly in areas like local marketing and does the Swiss principle actually have all the marketing expertise, or is it us Germans, or us French? It's going to be pretty messy, and I think will lead people to thinking about, aren't there more fundamental things that need to be done in the transfer pricing area 5 years from now?
So I agree with Bob and Paul. I think there are concrete things that have already come out of the BEPS project that are meaningful contributions to the international tax landscape. But I would actually really just echo what Bob said in his prepared remarks, that institutionally, the big change with BEPS is the involvement of the G20 in international taxation matters. And the G20 does have quite a lot of influence in terms of how individual countries then act on the areas where the G20 is weighing in. And I think that's critically important. The other important piece that has come out of BEPS is we see the European Commission and the EU institutions taking a more active role on direct taxation as well. And they do have mechanisms to force member states to sign on to certain types of proposals. So I think those are critically important changes coming out of BEPS.
Okay, so what does the audience think here? Can we vote on this? Yes? No? Yes, but. Yes, but deals with disruption and confusion.
I didn't realize we had that. I didn't have to know we had that on.
We divided up the ORC laws at least.
Okay, yes, 44%. BEPS will go forward and make a meaningful contribution to the interpretation of international tax rules. No, BEPS is going nowhere and will soon be largely forgotten. 50%, yes, but before it goes away, it will unfortunately result in disruption and confusion. So,
Fit the rest of the
Either way,
okay, so
either
we
way.
have just a couple of minutes late but, to go, but let's, so keep your comments short, guys. The sixth debate proposition, if the U.S. corporate tax rate is reduced, should pass-through entities help pay for that reduction? Pointing out that corporate tax revenues are now down to 11% of governmental revenues, and more than half of business receipts are now reported by pass-through entities. So what do you think?
I would say that yes. I think one of the important things to ask is how is the tax burden on the corporate sector compared to that of the non-corporate sector? And we haven't really known that because there hasn't been good empirical information about how much tax is really being paid in partnership by partnerships. But there's an important empirical paper that came out recently, or is coming out, that actually was featured in my colloquium 2 weeks ago, written by a bunch of Treasury people and a bunch of academic economists like Danny Yegan and others. They basically did an empirical study based on matching things that hadn't been matched before in the IRS tax files about the entity level versus the partner level returns. And they find suggestive evidence that partnership income is quite low taxed in this country, lower than corporate, and in ways suggesting not just tax exempts, but also a lot of tax planning that we don't really quite understand yet, although of course partnership tax experts could fill in the phrases a little bit.
Bob?
I'm with the professor. I think that there's a lot to be said about both the level of tax on the pass-throughs and on the fact that if we're going to do business reform and the entities that operate in a single level tax system, remember it's not a double level tax system, can afford to bear part of that burden.
Michael?
Yeah, I think I would agree with that. I think that we've seen tax reform several times over the past handful of decades, and I think it is important to think about the disparity in terms of how corporate income is taxed versus how it's taxed in the pass-through context, and trying to reduce that disparity is going to be an important part of tax reform.
Paul?
Yeah, I would say, I mean, this is one of the big dilemmas we have in tax reform, because obviously the pass-throughs are reluctant to see a tax increase, even if it's inevitable in tax reform. Somehow somebody needs to start making the case that their future is linked up with a lot of the futures of the major corporations in this country, so that they can see the need to come to reform that they do contribute to, that works for everybody.
David?
Yeah, I don't even understand how you would include the pass-throughs with the corporates without expanding beyond the pass-throughs. And what, are you going to have a scheduler system at the partner level? I don't quite understand how this would even work. So I'm of the view that if you're going to reform the corporate tax, you can do that on a standalone basis.
I think the idea is if you pay through base broadening, then that's going to affect.
I understand that,
yeah.
but what do you? Yeah, I understand.
Well, there is a VAT, but there's also the question of whether if you pay through it through base broadening, it'll ever happen, which is Paul's
Right,
point.
well,
I
that's
think.
true too.
Okay, so what does the audience think about this? Yes, the tax rate should be cut, and it's too bad if that results in base broadening. Yes, but go ahead and cut the corporate tax rate, but pass-through shouldn't have to pay for that. It could be funded by other changes to the corporate tax. No, corporate tax reform should be off the table unless we accept the revenue loss or require corporations to pay for it in full. So, what do you think? My gosh, 43% think the corporate tax rate should be cut, and it's just too bad if that results in base broadband. Obviously, not a lot of S corporations in the audience here. 40, that's 43. 42, yes, but go ahead and cut the corporate tax rate, but pass-through shouldn't have to help pay for that. No, corporate tax reform should be off the table unless they accept the revenue loss or require corporations to pay for it. So a real collision here. All right. Thank you.
Okay.